Hello everyone, so this is the English Law Channel. So I'm going to be looking now at Freehold Covenants. So neighbours, they often reach an agreement about using their land, and these are called covenants. So they're personal obligations, you can make them by deed, and the rules of contract are applicable here. So the parties of the covenants can enforce them. But if the covenants can be binding on successors in title, then there's some very tricky rules to understand. The rules about passing the covenants on, and we need to consider these particularly linked to common law rules and equity. So lots of these rules of covenants are an outgrowth of equity, and they are kindred to easements. So similar to easements, they create a relationship between two parcels of land. One of them is benefited by the covenant, the dominant tenement, and the other one's burdened by it, and is therefore called the servient tenement. So a covenant is a promise by which one party says that he will do something or will not do something pertaining to that land. The person who receives the benefit of the covenant is called the covenantee, and the person who's got the burden is the covenantor. Prior to bringing in strict planning law rules, this was a crucial way of regulating land use and keeping the value of the land stable, or indeed making it rise, but it wasn't going to fall. So a crucial way to ensure neighbourly relations and upholding the value of land was this. So positive covenants about the promisor doing something, such as keeping something in good repair. A negative or restrictive covenant is about promisor not doing something. For example, setting up a business, selling it to a certain category of person, building something. Okay, the covenants are simple enough to enforce between the original parties, because this is clearly a contract. But if either party sells the land on, then the enforceability becomes less clear. So a freehold covenant is a contractual agreement between two people or entities about the land. The covenants can be negative. Remember, the burdened party promises to desist from a certain course of action. That's not to build something too tall or whatever. These covenants can be positive, which then obliges the burdened person to do something, as in to keep a wall in a good state of repair or something. For instance, a covenant must be that something has to be constructed, and that's going to cost you money, and that's going to be time consuming. So this is a contractual provision in the first place, so the contract obviously binds the contracting parties. But the issue here is when the covenant will bind people who purchase it from the original contractors. So we have to ask whether it runs with the land and touches and concerns the land. The covenant must be about the land and not just the people, if it's going to be enforceable by future owners. So a covenant about cutting somebody's hair, for example, would be personal. It's not linked to the land. A covenant to keep a drainage system in good working order is something about the land. So the benefit of the covenant will pass at common law, and that's as per the LPA 1925, and you can find that in Federal Codes Limited against Mill Lodge Properties Limited, 1980. The burden of the covenant will not pass at common law, even though Section 79 of the LPA 1925 is there, and that's underscored by Roan against Stevens 1994. The benefit of the covenant will only pass in equity due to annexation, assignment, or a building scheme. Now, the only manner in which you can pass on the benefit of a negative covenant is through equity, as in Tulkad Moxie, 1847, but I think it was actually 1848 was decided, which is about the land which is now Leicester Square in London. You cannot pass on the burden of a positive covenant, even in equity. Roan and Stevens made that crystal clear. Okay, so let's look about the passing on of benefits and burdens. And covenants, freehold covenants and leasehold covenants, are a key way of controlling land use, and that was before the government became much more involved with like the green belt and so on, and having to seek planning permission, and controlling this land as a resource. So covenants are still used to make an area attractive to people, agreeing not to subdivide a flat or something like that, not to let out your parking space, for instance. And so purchases of a developed area like it, local amenities can be kept in a certain manner, property values can be kept high. It's usually thought good that the tenant covenants can be enforced by the new successors in title, and the enforcement of all covenants, no matter how unimportant they are, no matter how vague, however, could be too much of a burden on those who buy the servient land, and could it make it impossible to sell that land. So bear in mind the key principle of land law is we're trying to keep land valuable and keep it saleable. So you need to find an equilibrium between these various principles, and the development of freehold covenants has to be viewed in that light. So they usually call freehold covenants to tell them apart from covenants that the landlords place in the lease. So I'm going to look at the covenants that run with freehold land. And in this situation, there's no privity of contract, nor indeed is there privity of estate. So leasehold covenants is another issue. So a typical situation would be where, let's say, Victoria sells part of her land to Philippa. Philippa enters into numerous covenants which are in the deed. The covenants will be enforceable against the original parties. But what if Victoria sells the land on to somebody else? Philippa then conveys her land to this other person, to another person, and can these two new parties, the one Victoria conveyed to and the one that Philippa could convey to, can they enforce covenants? Well, that, you see, if a covenant is enforceable, that means it's an encumbrance over the servient tenement. To be enforceable, you have to prove the benefit of the covenant has passed and the burden of the covenant has also passed. So there are different rules about passing the benefit of the burden in equity. So this is quite tricky. Okay, so let's say Arabella owns Blackacre. Arabella has a covenant with Belinda about who owns Whiteacre. Then Belinda, who owns Whiteacre, makes a covenant with Arabella, the owner of Blackacre. Okay, so that's an exchange of promises. Then Arabella sells Blackacre to Charlotte. Is Charlotte bound by this, or does she have the benefit? Does she have the benefit of covenants that Arabella had with Belinda? Okay, but then looking at the servient tenement, let's say then Belinda sells it to Delia. Is Delia bound by this, or does Delia have the benefit of the covenants that Belinda entered into? So we have to think about what kind of covenants we're talking about here, because I told you it was tricky. Confused already? All right. So there are a number of things to consider. What are covenants? What kind of covenants are there? Promising not to build something new, promising that you'll pay to keep a driveway in good working order. It could be promising not to create a mess or something like that. So you have to see that who has the benefit and who's the burden. So let's talk about passing the benefit at law. Now, the covenantee in the beginning can always enforce the covenant against the original covenantor. This is a contract between them. So Section 56 of the LPA 1925 says that those who are not part of the covenant, as in those who had not signed, persons who exist at the time of the deed and mention the deed in the covenant, the covenant can be interpreted, as we've seen. It's straightforward for them. The courts have ensured that Section 56 does not weaken the doctrine of privity in contract. That's like, see, Ray Ecclesiastical Commissioners for England's Conveyance, 1936, White and Bijou Mansions Limited, 1938, Amsprop Trading Limited against Harris Distribution, 1997. If a covenant was made after the 11th of May 2000, the Contracts Rights of Third Parties Act, 1999, is also helpful. Section A of the said Act says that a person who's not a party to the contract can enforce it if it expressly provides that he or she may do so, or it purports to confer a benefit upon that person, so long as the contract identifies that person by name, or indeed by description as being a member of a group, as in, say, future title holders. It's immaterial if the person wasn't even alive at the time the contract was made. So the Contract Rights of Third Parties Act 1999 is much broader in its applicability than Section 56 of the LPA 1925. So let's look at successors in title. The benefit of the covenant can pass to a successor in title. Okay, and there are two ways you can transmit the benefit of a covenant to the covenant successor at law. So before thinking about the benefit running in the land, the covenants must first be about the land. Our common law benefits can run with the dominant land if certain requirements are satisfied. Well, there are three requirements and they all need to be satisfied. The covenant must touch and concern the land. Smith and Snipes All Farm Limited against River Douglas Catchment Board 1949. It must touch and concern land is found in Swift Investments against Combined English Stores 1989. Second of all, the covenantee and the covenanter's successor in title must have a legal estate in land. They don't have to have the same estate in land. They can have two different types of estate. They can have the same estate, either case, so long as they both have an estate in land, any estate in land. That's as per Section 78 of the LPA 1925. If it's intended by the original parties to run with the land, and this is vital, the vitality of this was somewhat doubted in Smith and Snipes or on Swift Investments. Okay, so those are the three requirements. The covenant can run by assignment or it can run by annexation. So express assignment is when the covenantee has actually assigned the benefit of the land to the successor in title, and it will say so in a document. The covenant cannot be personal. It's got to meet the more formalities. It's got to be about the land, and it's got to meet the requirements of Section 136 of the LPA 1925. So it has to be writing, and the covenanter must say it expressly. It can't be impliedly. This method is less important now. Anyway, annexation. The benefit of the covenant can be annexed to dominant tenement either expressly or the covenanting parties, or statutorily and through Section 78 of the LPA 1925. The LPA 2025 is not required that the covenanter's successors in title should own the same legal estate as the covenantee. This means the statute is applicable where the covenantee grants a legal lease of the dominant land. The statute is also applicable where the covenantee transfers part of the land rather than the whole of the dominant land. So that's a vital point. It might just be a very small section of that land. Nevertheless, it can pass on rights. Okay, toodle pip.